Good afternoon, everyone. My name is Sarah Barker, and I'm here with the Empowering Aging podcast. My special guest today is estate and trust attorney Rodney Hatley. Today, he's going to be providing some education on the 7 key questions you need to answer to make sure that your house is in order. Rod, thank you so much for being our guest today.
Sarah, thank you for having me. It's a pleasure to be with you.
Definitely. So why don't we go ahead and jump in, because we all know anybody in business is extremely busy. And so we'll just get right down to it. Anybody in the audience listening, whether you are an older adult, a senior, or you work with adults, or you're even a younger adult, this information is crucial, right? You have to do proper legal planning in order to make sure that your wishes, your desires are known and protected. And then also, to make sure that we are avoiding probate should something happen to you. So Rod, without further ado, I'm going to go ahead and turn the stage over to you.
Well, thank you very much. Why don't you go to the next slide? This is just more information about me. For those listening, I'm a former Navy JAG. So if you ever saw the movie A Few Good Men, that's what I used to do years ago. And what got me into estate planning was basically a 7-year probate after my father had passed away from leukemia. I knew enough about estate planning in the Navy to be dangerous, but I at least knew enough to say, Dad, given your various business interests, we've got to do more planning, because all Dad had was basically a simple will. And wills go through probate. And I know that he wanted to do more, but he was fearful because he had leukemia. So you understand why he couldn't do it ultimately. He did pass, and I took 2 weeks emergency leave. I went back to my hometown of Memphis, Tennessee. Week number 1, we got him buried. Week number 2, we opened up a probate, and that stretched into a 7-year ordeal for my sister and me. And that's not what Dad wanted, but that was the practical result of his inability to do more and better planning, given that he was so sick. So I hope that our conversation today will at least spur some of you to not delay while you're still healthy enough to be able to undertake this planning. You'll be able to, take our advice and get something in place sooner than later. Go ahead to the next slide, please. Mm-hmm. So these are the 7 key questions that you need to ask to make sure that your house is in order. We'll take them one at a time. And Sarah, if you may have any input, I'd certainly invite that as we have a chance to visit today. Go ahead and go on to the next slide. Okay, the first question that I would have is, are your healthcare documents current? And do your healthcare agents have access? A very key question, especially for clients who may be getting up in years. Perhaps they're housebound now, or perhaps they might be in an assisted living facility. Go ahead to the next slide. And why do I ask this question? Well, because life happens. What you're taking a look at, for those of you who can see this, it's a photo of my car. A few years ago, I got rear-ended on the highway. Luckily, I was able to limp away with abrasions and whiplash. But the bottom line is, had I had to go to the hospital, certainly I would have needed my healthcare documents available to my healthcare agents. And so that I did have them available. But if I hadn't had a plan in place, it could have been really catastrophic if I was in the hospital and totally non-responsive. So, tomorrow's promised to no one. So we need to be thinking today about how can we get out ahead of this and make sure that if something happens, we don't create a crisis for our loved ones. Go ahead and go on to the next slide, if you will. Okay, what you need are, well, at least for those listeners in California, other states will vary. You need an advanced healthcare directive. That basically says if I'm in the hospital, and if I'm in a permanent vegetative state or an irreversible coma, I don't want to be kept alive artificially. I want to, I don't want to be a drain on my estate. So I've empowered my healthcare agents to pull the plug, if you will, and not keep me alive artificially. A HIPAA authorization, now that's federal law. And what it says is that only those people that I've authorized to have access to my protected medical information may do so. So if I had to go to the hospital, only the people that I've authorized through my HIPAA authorization can talk to the doctors and the nurses, and also have access to my protected medical information and my medical records so they can make those important decisions on my behalf. And I also, for my clients at least, when clients hire me, we prepare their documents, and I also buy them a complimentary 3-year membership in a company called DocuBank. My healthcare directive and my HIPAA authorization are on deposit at DocuBank, and I have a card in my wallet next to my health insurance card and my driver's license, so that when I get to the hospital, if I can't speak for myself and they go through my wallet to identify me, they'll find that card. It has a toll-free number that can be reached 24/7, 365, and a copy of my healthcare directive and my HIPAA authorization can be faxed over to the hospital. And also, my healthcare agents will be notified via email, and they know now to go to the hospital. And when they get there, the document should be ready and waiting, and then they can make those important decisions on my behalf.
And I think, Rod, I would imagine this is especially important when we talk about older adults where
Yes.
maybe someone's mother lives here in San Diego, yet the adult children or any other family members, particularly the ones that have been authorized, they live in New Hampshire, right?
Sure.
And gosh forbid something happens to mom, do those healthcare professionals, how are they going to know who to contact as soon as possible?
Exactly right. Yeah. Excellent point. And all the more reason why we encourage clients to get out ahead of this. Let's work together and prepare an ironclad plan that will take care of them. As I say, tomorrow is promised to no one. So because we don't know what the future holds, let's prepare for it as best we can now.
And stop me if this isn't the right time and you're going to get to it later, but the importance of these documents being reviewed, what your wishes may be right now and who you want to carry out your wishes or have your information could be certain people right now, but that may change 10 years from now, right? So the importance of reviewing these.
Yeah, I make the DocuBank membership for my clients good for 3 years. And there's a reason for that. About every 3 years, I think we ought to be getting back together. We ought to be reviewing their plan, making sure things are going the way they want them to go. And if they're not, well, then obviously we can change. So about the time that DocuBank membership is about to expire, I like to have the clients come back in and let's sit down, and for no fee, I review everything with them. And we can even do a phone call or a Zoom call if that makes it easier for the clients. They don't have to physically come into the office. But the point is, let's review this periodically. And if it turns out everything is fine, terrific, we give them a clean bill of health, we will renew the DocuBank membership for another 3 years. So they're now protected additionally. And in 3 more years, we'll have a chance to visit, I hope, again, to make sure that we're staying on target with their plan.
I love that you have that in there, right? Because it ensures that touch point to make sure that the wishes and everything is still the same. Okay, well, moving on to question 2.
Question number 2 is, does your plan avoid probate? And there are 2 kinds of probate. Now, the one I think most of us are familiar with is the death probate. And when someone has passed on, if they have a will, we take the will to the courthouse and we file it, and then we have to probate it, which is basically we have to figure out what they own, pay off any debts that they owe, and whatever's left over, we distribute to their ultimate beneficiaries. But there's also a living probate, which is basically, I'll pick on myself. If I became incapacitated as the result of an injury or a disease, then if I didn't have anything in place, at some point, someone's going to need my signature. The way they get it is they put me in front of the probate court judge downtown, and they say, Your Honor, this is Rod. He's incompetent now to manage his affairs. Please appoint me, some third person, to be his conservator, which is basically a guardian for a grown person. And then that way, that person has to report to the court every 2 years. How am I doing? How are they spending my money? How are they managing my assets, etc.? And that's not really what I want. I mean, I don't want to be subject to the probate court's jurisdiction. And so the best way to avoid that is to have a plan. And we'll talk about it in a little bit, about how we can get out ahead of this and make this a non-issue. But does your plan avoid probate, whether it's a living probate while you're alive, but maybe you're not well, and certainly after you've passed on someday? Go ahead and go on to the next slide. We'll delve a little deeper. As the slide here says, wills don't avoid probate. Actually, they guarantee probate, either while you're alive or certainly when you pass on. And remember, too, that wills only become effective when you die. So if I had nothing in place except maybe a simple standalone will, and I had one of those years ago, but I got a little bit smarter, and that's why I set up a living trust for myself. But anyway, if I became incapacitated mentally, I'm looking at a conservatorship, and that takes time. It costs money. It's a matter of public record. I don't want that for myself, and I certainly don't want it for my loved ones. And certainly someday when I pass on, If all I had was a will or no will, assets would have to go through probate, and that takes time, costs money, and again, is a matter of public record. So go ahead.
And Rod, I'd like to add a little bit onto that too. And this is what I want families to understand. A part of doing this planning, right? Rod just said the probate process can be expensive, stressful, timely, but consider this. Because your family is having to deal with those legal proceedings, it can actually delay the grieving process, right? Versus being able to grieve the loss of you and process all that. Now they're having to deal with this legal situation.
It really compounds the situation. It adds insult to the injury. You know, the injury is the loss of the loved one, but now we're having to deal with stuff that, you know, if we could have got to them early enough that we might have convinced them, hey, let's get out ahead of this. You know, you're going to have these issues. Let's talk about it. Let's come up with a plan that will really take care of you and take care of your loved ones later when you're gone. And we can avoid the stress and, it's an awful mess. And having lived through a 7-year probate, I can tell you, anytime we can keep a client out of probate court, that's a great day in my book. Okay. All right. So let's see. Let's talk about a will plan. Wills don't guarantee privacy. In fact, they're a matter of public record. They get filed at the probate court downtown. They're expensive. It's basically based on a percentage of the estate. And we can talk a little bit more about that in one of the upcoming slides. It doesn't control all property. So, for example, if you have life insurance gets passed down by operation of law, by contract. So let's say Sarah was my beneficiary under a life insurance contract on my life. When I pass on someday, all she has to do is provide the life insurance company a copy of my death certificate. And since she's the designated beneficiary, she gets that money, never has to go through probate. Or if it was a retirement plan and she was the designated beneficiary of my retirement plan monies, then again, she gives a copy of the death certificate to the plan administrator, and then they give her the money. And a will actually guarantees probate. It doesn't protect you while you're alive and well, or if you're alive but maybe not well, but it only takes effect when you die, and it guarantees probate. Go ahead and go on to the next slide. This slide is really just an example of the costs of probate. It can get fairly expensive, and I'll just give the example of, let's say that somebody here in San Diego owned a home, and maybe say the fair market value was $1 million. Not unreasonable, fairly typical. But let's say that they only had $1 of equity. We don't care what the equity is. What we want to know is what's the fair market value of that property. If that property is worth $1 million, then the statutory probate attorney's fee on that is $23,000. The personal representative, sometimes called the executor, the personal representative gets a like amount of money, so another $23,000. And you add it together, it's $46,000 on a $1 million piece of property. So call it 4% if we're going to round up. And so, and that's just for probating that one particular asset. That doesn't include anything else. So it can get expensive very quickly. And so for a fraction of that, we can set up a great estate plan ahead of time that, if we keep it updated and maintained, means it will never have to go through probate. And it will keep, we try as much as we can to ensure family harmony and reduce the stress level for the loved ones who live on after we're gone. So that's
right. And I mean, and think of it this way: why would you want to give $46,000 to the court system, the government, right? Versus that's $46,000 that could have been left to your heirs.
Yes. Yeah. Exactly. And so, I mean, if we can get out ahead of it in time, I think we can really do a great job saving the family money. It's still an investment, of course, to get this all set up and keep it maintained going forward, but it will be a lot less expensive than a very expensive probate later on after they've passed. Okay, so sometimes in this slide, for those who can see it, and of course, if you're just listening, we're going to talk about joint tenancy. A lot of people know what that is, but my point here is that you usually cannot avoid probate by using a joint tenancy. We'll talk about that a little bit more. So go on to the next slide. Okay, joint tenancy can produce unexpected consequences. And go on to the next slide, and we'll take a look at how that can play out. So in the example here, we have a mother, and she's got three let's call it 3 adult children. She's got a daughter and 2 sons. And the first son has 2 children of his own, a son and a daughter. So basically, they are mother's grandchildren. Okay.
Mm-hmm.
And what mother decides to do is she's got a certificate of deposit. And she decides, you know what, I'm going to add all 3 of my kids to this CD because I figure I'm going to die first. And I want them to be able to split these proceeds equally. And I think that's a good way to do it. And, not unreasonable. And a lot of people do that. So go on to the next slide. And so, but the hiccup is that in this scenario, the first son passes away unexpectedly. It happens. So now mom only has her 2 remaining children, daughter and son number 2. And go on to the next slide one more time. And then mom passes away. All right. So now the question is, okay, who's going to get the CD? Remember, let's go back. Son number 1 is the first one to pass. Mom then passes. So now we've got daughter and son number 2. And also remember, son number 1 had 2 children of his own, a son and a daughter. So the question is, who gets the CD? Go ahead to the next slide. And one more time. There you go. Well, who gets the CD are the surviving joint tenants. Remember, mom added daughter, son number 1, and son number 2 as the joint tenants with her. But if son number 1 has passed on, he's out of the picture. Now mom has passed on. Now who gets the CD? Well, it's going to be the surviving joint tenants, daughter and son number 2. But wait a minute, didn't I say that son number 1 had 2 children of his own, a son and a daughter? What about them? What do they get?
Mm-hmm.
Go on to the next. They get 0. They get nothing. So they got aced out. And so you would think, well, gee, wouldn't they take their father's share by representation? You would think that, but in fact, no, they don't get it. Now, I've seen situations where the surviving joint tenants say, you know what, we really feel badly about this, and we want to cut you in for a share. So the third that would have gone to your father, we're going to give each of you, a sixth of that. So that'll be a third. And so, and that's the right thing to do. Now, and that's great, but that probably doesn't happen all that often. I mean, legally and technically, the CD is now owned by daughter and son number 2, and they can tell their nephew and niece to go pound sand. They don't have to do anything, which is unfortunate. Okay, so go on to the next slide. So here, keep in mind that joint tenancy only works if, number 1, no one becomes incapacitated, everyone dies in the right order, no joint tenant has a judgment creditor, and the senior generation is comfortable giving up control. So if we go back to the case that we just talked about, we hope that mother was fine giving up control by adding her 3 kids to the CD. But, some people might not like to do that. So there are other things that we can consider, and that won't have a bad result, such as, adding the kids to the CD. Son number 1 passes first, and mom passes, and now, it has the unintended consequence of only making daughter and son number 2 the beneficiaries and cutting out the grandchildren. Okay, go on to the next slide. Let's talk for a moment about how to own real property. Here in California, I think you're absolutely foolish if you have a home and you don't have it owned by a living trust, because when you pass on someday, that's going through probate. And as we've already discussed, if that fair market value, and I'll just use a really simple number, it's worth $1 million. It's worth $1 million. I don't care what the equity is. We're looking at the fair market value. If the fair market value is $1 million, then that's going to go through probate. And again, for $1 million, it's $23,000 to the attorney, $23,000 to the personal representative, $46,000 combined. Call it 5% of the value of that asset. And I do have a note here that if you have rental property, it might make sense to consider setting up a limited liability company, which builds a wall of protection around that asset, because it's what we call a hot asset, because you've got liability associated with it. You might have mold and mildew, you might have asbestos, you might have lead paint poisoning, all these things. So an LLC can kind of shield that asset so that if there's a lawsuit later, it has to be confined to that LLC and it doesn't contaminate the other assets that the client owns. So go ahead and go on to the next slide. Okay. So the solution really is a living trust plan. And I think it makes a lot of sense because remember, wills only become effective when you pass on. They don't do anything for you while you're alive and well, or alive but maybe not well. And so a trust is the best answer that we found for clients here in California and in a lot of other jurisdictions as well. A fully funded revocable living trust. Now, what does that mean? That sounds like a bunch of gobbledygook. Fully funded means that it owns all of the assets. So your home, bank accounts, brokerage accounts, it might be the designated beneficiary of your life insurance. And if your kids are young enough, maybe it makes sense to have it the designated beneficiary of your retirement plan monies. And the living trust is revocable, so you can amend it, you can revoke it. Hope you wouldn't do that, but it's your trust. You can do what you want to. But that's the centerpiece, if you will, of an estate plan. And we really want to round out that living trust with some other documents. A durable power of attorney to manage assets, non-trust assets, like, for example, the retirement plan, that sort of stuff that wouldn't ordinarily be owned by the trust. And then I like to also include what's called a pour-over will. Now, you might be thinking to yourself, well, Rod, I thought you just said that a will was bad. Well, a standalone will is going to guarantee probate, but a pour-over will is different. What does that mean? If an asset, let's say I'll pick on myself again. If I had set up my estate plan and maybe there was an asset that should have gone into my trust, but you know what? I got busy, life got in the way, and then suddenly I'm out of the picture. A pour-over will acts as a safety net to catch any asset that I have in my individual name. And if it has to go through probate, then I've nominated people to serve as my personal representative to shepherd that asset through the probate process. And when that concludes, then pour it over out of my probate estate into my trust. So it's called a pour-over will. So it's a safety net. We hope that we never need it, but it's there if we do. Okay.
We have a comment. She said that you explained that very well, Rod.
Well, thank you. Very cool.
Would you mind,
go ahead.
Real quick, because I didn't know years ago what attorneys were talking about when they were talking about how the trust has to be funded, right? I'd shake my head and say, okay, but as the years have gone on, that is really important. That is a crucial aspect of this, because if it's not funded, then it's basically useless. So can you explain in more detail what it means for the trust to be funded and why it's so important?
A great question. Funding is a lawyer word. It means changing the names on the things that you own so that they're now owned by the living trust. So for example, in my case, when I set up my trust years ago, I put my bank accounts and my brokerage accounts in there. I transferred title to my condo into the trust, etc. So now my trust is funded so that if I become incapacitated mentally, my successor trustee will take care of me, will take care of my assets, etc. And there won't have to be a conservatorship, that living probate we talked about. And then, of course, someday when I pass, because the assets are owned by my living trust, they will never have to go through probate. And let's see, what was the other part of your question?
I think it's important for people to, people will spend a bunch of money to get the documents drafted and everything, but then you hear these horror stories of now all of a sudden something does happen and they think that they've done all this planning and all the money was paid, but it goes to probate anyway, and it's because the trust wasn't funded. And so that is such a crucial piece. People have to understand that if you don't name the assets in the name of the trust, right? That's the funding part. It's not going to matter, right? You just spent a bunch of money for no reason at that point.
Well, you've got a stack of pretty papers, but they don't do you any good. So all the more reason why when clients hire me, we establish the relationship. I have that DocuBank membership for 3 years for a reason. About every 3 years, I'm going to have them come back into the office. Let's talk about what's happened in the past 3 years. The laws may have changed, and we just recently had a big change in the law a couple months ago. Their personal situation may have changed. They may have adopted a child. They may have, and people that maybe they nominated originally as a successor trustee, maybe that person has become elderly or possibly has passed, or maybe they've had a falling out, so they no longer want that person to serve. So we ought to be taking a look at the plan. There's really no way that you can sign a plan one time that it takes care of everything for all time. It just doesn't work that way because, life is nothing if not dynamic, and the laws are going to change. And actually, interestingly, my experience gets better. I learn new things all the time that I can bring to bear for the benefit of my clients. And so my hope is that, we can, keep the plan updated and maintained so that someday when disability or when death comes, it's a much easier plan to administer to be able to get the assets to the ultimate beneficiaries.
That makes sense.
So here's how a revocable trust avoids probate. So we'll take it from the standpoint of you have property in your personal name as opposed to you have property titled in the name of your living trust. That's funding, in other words. So property in your personal name goes through probate before it gets to the heirs. And probate is that process of figuring out who did you owe money to when you passed away, because death doesn't extinguish any debts. And then making sure that once those creditors are all paid, whatever's left over, if anything, gets to your heirs, whoever you wanted to receive it. Now, contrast that with the property that's titled in the name of a living trust. When you pass on, no probate, because those assets in the name of the trust just pass down to your heirs without ever having to be tied up in a multi-year court procedure like a probate. So a living trust is definitely the better answer here. And it's really what we recommend for our clients if they have a home. And even if they don't have a home, but maybe they've got stocks and investments, et cetera, it makes a lot of sense because it's going to avoid probate either for incapacity and certainly for death. Okay, go on. You can think of a living trust as kind of like a chest. Everybody's seen a chest of drawers. You can think of it as like a chest, a treasure chest. You put your assets into the chest, you close it, you lock it up. And so assets that are in the chest or in the trust don't go through conservatorship, don't go through probate. Much better answer. And go ahead, next slide. We can create separate drawers in the chest to serve specific purposes, and we'll talk in a little more detail shortly about how we can set that up. Okay, go on if you'd like. Question number 3, and we've spent some time talking about this, but I think it's pretty obvious. Is your living trust fully funded? And so again, have we put the assets into the trust so that they're not going to go through probate? And, we also, again, we supplement that trust with a pour over will to make sure that any asset that should have gone into the trust that didn't get there because life got in the way and then suddenly I'm out of the picture, those assets will ultimately wind up in the trust, which is really what I wanted. Okay, go on.
Rod, is it difficult? Is it difficult for someone to get the trust funded? Is that why people delay they do all the money and then don't fund it?
It's a great question. In my practice, if clients own real property, we're going to prepare the deeds that they're going to come in to sign that will transfer the properties into the trust. And then we'll record them with the county recorder so that it's in the chain of title showing that, in fact, this asset is owned by the living trust. For bank accounts and brokerage accounts, clients can hire us to do it, but I don't think they really need to spend that money. We will provide unlimited guidance. So, we will provide them paperwork and we'll tell them, now, this is what you need to do. Go to the bank and retitle the account. Sometimes I have to close out an existing account, open up a new one in the name of the trust. That'll happen. And also for brokerage accounts that they might have, we can provide paperwork to their financial advisor, and he or she can retitle that account in the name of their living trust. And so that's really, and it's not that difficult, but it does take time. And I think when I did mine years ago, I think it took about 6 weeks to get everything from start to finish. But it really doesn't take long, and it's much better than multi-year probate. So I always encourage folks, and I always say, look, I charge a fixed fee for what I do. I don't bill for phone calls, emails, faxes, text messages. If you need to reach out to me, reach out to me. If you just need guidance, I'm happy to provide it, because I think that's what you've hired me for, is to be that trusted advisor to help you make those important decisions.
Yeah, and I think the moral here is, if you're paying to get the planning done and you do it, don't delay on funding it, because you never know. You said tomorrow's not guaranteed. We don't know, you could end up with a disability tomorrow, incapacitated or pass away. So this is something where if you've done it with your attorney, don't delay in getting the trust funded, right? Just
exactly
get it.
Right.
Okay.
Question number 4 is, are you happy with your plan? We talked about this already in a way. That 3-year update that we do, update their DocuBank membership. We say, come in, your card's about to expire, so we want to review your situation. Clients might have had, they might have nominated guardians in their wills, their pour-over wills for their minor kids. And now the kids are over 18. They may have even grown up, gone to college and got married and started a family of their own. So there might be grandchildren at this point. Also, trustees, somebody you selected previously to serve as a trustee, maybe that person is no longer in your life, or perhaps you've had a falling out or whatever, or maybe they don't really want to serve and we need to find somebody else who can help. And then the beneficiaries, maybe you've added to your family, you have more kids now, or you've adopted a child, or maybe someone has passed on, heaven forbid. But so we need to clean up the beneficiary designations not only in the trust, but also for, say, life insurance or retirement plan monies too. So we just want to make sure that the plan is updated and maintained, so you're happy with it.
And perhaps this is a good time for you to speak about how being the trustee is a responsibility. So when someone is doing planning, to make sure that you have a conversation with the person you want to designate and explain the realities of it, and find out, do they actually want to do it or not? Or should you look for a third party trustee?
Great question. If you have people that you trust and you possibly had a conversation, hey, look, I think so highly of you and I respect your ability, etc. We've recently set up a living trust, or we're about to sign a living trust. I would like to have you serve as my successor trustee, so that someday when we're no longer here, you're the trusted person in that role to make sure that the beneficiaries get what's coming to them in a way that works for us, as we've set forth in our documents here, our instructions contained in the trust. And sometimes, it's happened to me a handful of times, a client maybe is new to the area, or maybe, just their other family members, or they didn't come from a large family. Mm-hmm. They don't have a lot of friends. So it might make sense to consider what's called a private professional fiduciary. That's somebody who is licensed and bonded by the state of California. And that's what they do for a living. They serve as a trustee of a living trust. And also, sometimes clients, if they have a great banking relationship, they might have a corporate trustee. Probably don't see that as often. Usually you only see that with clients who have a lot of wealth. And so it might make sense, just to keep the family from fighting after they've passed on, to have a corporate trustee in place. But that it's on a case-by-case basis. So but if you're going to nominate an individual, just make sure you've had a conversation with them. And just because you nominate them doesn't mean that they have to accept it. They could decline, not because they want to be mean, but they may not have the time to do it. They may not have the ability to do it because their life has gone in a different direction, etc. So it's always valuable to make sure that you've had that conversation.
Or they may not want the friction, because we see this family dynamics. They may not want to take on that responsibility because they already know that it's going to cause friction, right? And being that with their siblings. So I guess what we're saying to the audience, Rod, is that there needs to be a whole discussion around that topic, right? When we're discussing.
It's important. Yeah, it's part of the counseling that we do with clients, is just to make sure that, who are your trustees, and do you trust your trustees? Are you comfortable having these people step in to that role if you're incapacitated, or certainly when you pass on someday? So, it's better to ventilate this ahead of time so that we don't have a problem later on. Okay. Question number 5, have you protected your spouse from the next spouse? Whenever I meet with a married couple, I always say this to the husband. Now, I know you love her and you trust her implicitly, but you probably don't trust her future spouse. And we all laugh and we have fun with it, because you have to have some fun with this, because we're talking about a really serious topic here. It can typically, the husbands in my situations always pass on first. It's genetics or against us. It's what it is. But we can, we can say that, if the husband in my scenario passes away first, the wife decides to get remarried, and we want to encourage it. I mean, we want her to be happy, of course. But if she gets remarried, now what happens if she's the spouse that passes next? Okay.
Mm.
So what's the likelihood? You kind of know where I'm going with this. What's the
Mhm.
likelihood that the money that mom and dad wanted to leave to their kids doesn't now go to the surviving new spouse or the new surviving spouse? So
Right.
go ahead and go on to the next slide so we can kind of talk about that. We create a testamentary trust in your living trust. So basically, this is a trust that pops out of your living trust for the benefit of your surviving spouse. And we can nominate a co-trustee to serve with her or him, depending, so
Mhm.
that we trust that spouse. We want him or her to be happy. If they want to get remarried, that's fine. But we also want to make sure that we protect that spouse and we don't unintentionally disinherit the joint children because the surviving spouse got married to a new spouse, and now that surviving spouse is the first to pass in that relationship. So, we try to protect those children from being unintentionally disinherited, and that can
And
be
these things happen, right? These things happen because there
they
wasn't
do
proper
happen.
planning
They
or
do happen,
discussion.
and the case laws are full of situations, and they're horror stories. If the attorney had just taken a moment to say, "Look, we're going to have a little fun with this, but it's very important that we talk about this. How can we set this up so that we don't unintentionally disinherit the children, your joint
Yeah.
children?"
And can we agree? I mean, it's not just about the fact of it being assets or money. I mean, this is about a legacy that people
Sure,
have worked very, very hard, right, to
no
generate. And
doubt.
so you don't want to, unintentionally lose that money outside of the family, right? Because it's about legacy.
Exactly right. Yeah, and we can talk a little bit more about legacy in a little bit. It's not just all about the financial assets. It can also be about the stories and where they came from and all those lessons learned, and that's also very important too. And we can pass that down.
Mm.
Question
Mm.
number 6 is: have you protected your heirs from divorce, bankruptcy, creditors, and their own immaturity? And here, for those who can see the slide, you've got a guy behind the wheel drinking out of a bottle of beer. So yeah, probably, and it happens. I mean, but we want to make sure that when we set up the planning, we protected our children, our ultimate beneficiaries, from lawsuits, divorcing spouses, their own immaturity, etc. Go on to the next slide, please.
Mhm.
We want to protect your family from the dark side of wealth. Uh, Warren Buffett, the famous investor, he had said something which I thought was really keen. He said, "Leave your kids enough that they can do anything, but not so much that they can do nothing."
Mm.
So we want to incentivize our kids to not just be a trust fund baby, but to get out, work for a living, get educated. Go to school, pick a profession, or pick a career, and maybe the money that they've left you can be used to supplement that. Maybe it can be a start on a great retirement plan for yourself, or maybe to invest in an extraordinary business opportunity. And ideally, the kids don't need to live off this money, but they can use it to supplement opportunities, etc. And they've got their own career where they're making money, etc. So we want to protect them. We want to encourage them to be productive members of society and take care of those people who rely upon them for care and protection, etc. So
Mhm.
go on to the next slide. The Ohio State University did a study, and what they concluded was it takes about 2 years to spend an inheritance. Before that study had come out, I think anecdotally, it was about 18 months start to finish. Whether you got an inheritance, you won the lottery, money doesn't come with instructions, unfortunately. So people just tend to blow through the money. They don't think it's going to, they think it'll last forever. It doesn't, and suddenly they wake up one day and, they're actually upside down. The money's
Mm.
gone. They actually owe more than they ever did before. So we want to protect our beneficiaries, whether they're children, grandchildren, whomever. We want to protect them from the mistakes that we can all make. But if we can get smart about it, we can avoid those. And so good planning can help avoid those mistakes.
Mhm.
Go ahead.
Mhm.
Next slide. The solution here would be to create a testamentary trust. And when I say testamentary, let me explain. That means something that pops out of your living trust. Okay, so it's after you passed on. And we can set up a testamentary trust for the benefit of your heirs, whether they're your kids or your grandkids, whomever. And you could even engage a corporate trustee. Or if you don't want to do that, you can say, well, and the way I usually design these and when I work with clients, I say that when your kids, up until about the age of 30, the kids need to have, they can have access to their trust share for whatever they need. They have to show genuine need. But when they turn age 30 and beyond, they can now become a co-trustee of their trust share. They can have more control over it and say, well, I want to take about 2% of the trust assets. I want to invest them with my college roommate who I know is going to have the next Facebook. So it makes sense to just be really careful about how we structure this. And because they're working with a co-trustee, if heaven forbid they get sued or they have a divorcing spouse, they can resign as a co-trustee. They still have a trustee in place to make distributions to them for health, education, maintenance, or support. Those four purposes that the IRS recognizes, basically anything consumable, but they don't include paying a lawsuit. So that's the best asset protection. That's the best asset protection that we can give people that we care about.
And I mean, everybody's different, but there is a lot of maturing that happens from 18 to 30. Absolutely. And even from 30 to 40, right? So putting those protective measures, protecting your heirs from themselves.
Yeah. And, I think one hopes that we get a little bit smarter as the years go by. I just cringe when I see, an outright distribution out of the trust to a beneficiary at age 18. I just want to scream because I know that it's going to be, it's like giving a child a loaded gun. I mean, someone's going to get hurt. And so, 25 is a little bit better because if they've gone on to college, let's say they've graduated, but I think 30 is a great age because if they went on to college, they've graduated, they went on to a professional program like business, law, or medical school, they've graduated, and they've worked in the real world for a couple of years perhaps. And so they're a little bit smarter about how the world works. So I think that's a much better answer than to just leave it outright free of trust certainly not at 18, maybe not even 25, but I think 30 makes a lot more sense these days.
It does.
Okay. You can also think of a trust as kind of like a safe. You can see the combination dial there. So, you can protect those assets from, and there are some children, some kids, they're good kids, but they just have a really soft heart. They're a soft touch. They just, they hate to say no. And it's great for them to be able to say, you know what, I really wish I could help you. You've asked for some money and I totally understand your situation, but you've got to go talk to my co-trustee because that's the one I have to get his or her buy off on this. So, that gets them off the firing line until they go talk to the trustee and that person says no. And that's fine. And that's a good answer. And it just allows the kids to still be nice, but say, look, you have to talk to my co-trustee. I'm not allowed to make these decisions on my own.
Yeah, it's another protective measure for them.
Absolutely.
To make sure that they're not exploited. Really, it sounds like that's what we're talking about.
Okay. Question number 7, have you protected yourself and your family from the cost of long-term care? Probably for your listeners, Sarah, I think this would probably be really key, but let's talk a bit more about it. Go on to the next slide, and I think we'll take a look at what some of this is about. 70%, as I understand it, 70% of Americans will spend some time in a nursing home, and the costs of care can range anywhere from $5,000 to $15,000 per month. I mean, that's anywhere from $60,000 to $180,000 a year, which is just staggering. Medicare does not pay for long-term care, unfortunately, and Medi-Cal, which is Medicaid as it's administered through California, so we give it the name Medi-Cal, only pays when your assets are reduced down to less than $2,000. So, gosh, it take, especially as clients get older. Now, if they've got, if they've got enough assets to be able to pay for that, then that's terrific. But sometimes clients don't, and so we have to take a look at what can we do to help them make sure that we preserve assets for the benefit of the family. Go on to the next one. Should you transfer the property to others? Well, you can. It's never a question of can you, but it's a question of should you. There are look-back periods that apply. So if you're applying for Medi-Cal, here in California, we're going to look back 30 months. What did you give away within the past 30 months? That will determine your eligibility. And if you've given something away, then that disqualifies you for a certain time period. Interestingly, the VA has a great program called the Aid and Attendance Benefit. I've worked on a case like that a number of years ago for a client. She was the widow of a military member, a veteran. And it's a great program, but they have a 3-year look back period. So, these are, as our senior clients start to look into this kind of planning, they just have to be aware of the look back periods. Okay, go on to the, let's talk about 3 reasons not to give property outright to your children. Okay, and we've already seen this already. They can die before you. Now what? They could lose it either in a divorce, a lawsuit, a bankruptcy, or if they fail to pay child support or income taxes. Child support and income taxes, those are really, the government is a super creditor, so they can come after you for those assets, for that money. And if you give property to a child, then they get what's called carryover basis. So basically, one of the only good things about dying is that whatever property you leave to your children, let's say you had a home, you bought it years ago for, easy math, $100,000, and when you died, it was worth $500,000. So the capital gain on that would be $400,000, the difference between what you paid for it and what it's worth when you pass. But there's something called step up in basis. So when you pass on someday, the property that you bought for $100,000 that is now worth $500,000, it gets stepped up to that $500,000 basis. So you owe 0 capital gains tax on it if you receive it as part of your inheritance. But if mom or dad or both gave it to you, you're going to have their basis in it. So whatever it was when they purchased it, say it was $100,000, you get that carryover basis. And now someday, when you go to sell it, guess what? You're going to owe capital gains on that $400,000. So, we just have to, and ideally, as we undertake to do this planning, we're talking with all the other.
Oh, Rod, I can't hear you all of a sudden. No? Yeah, that's strange. We were hearing you just fine, and then it cut out.
Darn it.
Oh, I hear you again. We're good.
Okay, thank you. I apologize. I don't know what happened, but anyway, the idea behind this is, before clients are giving assets away, it can make sense if it's a fully considered part of a fully considered program of gifting. But I just cringe when I hear people are giving away assets. I'm just thinking, did you think through this? Did you talk to your other advisors, like someone like Sarah, your financial advisor, your income tax, your CPA, your estate planning attorney? Just get these, make sure these people are in the loop so they can issue spot, and just make sure that you're not making a mistake by giving assets away.
Right. Don't be consult with advisors on this, and don't
exactly
be
right.
in a bad dash before you have these full-on conversations. So that way, you're making a fully informed, educated decision. We have exactly a comment, Rod, Mr. Thomas Glasser, not sure how to pronounce it, but he said that you are a great guest.
Well, thank you very much. It's very kind, Thomas. So thank you for sitting in. I hope this is valuable for you. Okay, go on to the next slide. So let's see. Transfers to a revocable living trust, an RLT or just a living trust, will not qualify you for Medi-Cal or VA benefits. So, a living trust is fabulous because if you become incapacitated, you've got a successor trustee in place to take care of you and your stuff. And of course, someday when you pass, assets in that trust will never go through probate, which is a real win for the family. But it's not going to help you for either Medi-Cal qualification or VA benefits. So, if clients are elderly and they want to take a look at this kind of planning, then you really need to be working with somebody who's going to take a look at what you've got going on to make sure you've got the right, you're pursuing the right strategies. Okay.
Mm-hmm.
Okay. So what are the solutions here? Well, have enough money to privately pay. And, if clients have that, if they're fortunate enough to have enough money to be able to privately pay, that's a great answer. There are new insurance and annuity products that seem like they get developed every day. I don't sell those, but certainly Sarah, as a care manager, she can help you get in touch with the right person to help have a conversation about that. There's something called a Medi-Cal Asset Protection Trust. I've done those in years past. I don't do them anymore because it is an investment, and I think clients just kind of go into sticker shock. But if we're going to protect assets from Medi-Cal reach back, we want to make sure that we structure it the right way. And it is an involved process, but for the right client, it can be something worth pursuing. And then finally, there's the VA Asset Protection Trust. That's the VA aid and attendance benefit that we talked about earlier. I don't do that, but there are great attorneys in San Diego where I practice who do that kind of work on a regular basis. And if you are here locally and you need some help finding someone like that, feel free to reach out to me. I'd be happy to get you in touch with somebody that I know and respect, and I know would do a great job for you. Okay.
Mm-hmm.
So those are the 7 key questions that I hope that have been helpful for you. You just need to ask and answer those questions, and I think that will give you set you up for success in making sure you've got the right plan in place, you've got it updated and maintained, and as you may consider other kinds of planning, like say Medi-Cal planning, that can be part of the overall conversation that you're having with your advisors. Let's see, go on to the next slide. I think there was something else we can just ping on here. Or is that it? Yeah. For those watching at home, if not having your estate plan often results in a train wreck, and you can see exactly what happens there. So it's not fun for anybody. And it, having lived through a 7-year probate, I just encourage folks, get out ahead of this. Find a good attorney to help you and make sure that you put a great plan in place and keep that plan updated and maintained. And I think there may be some additional slides here. I know we're limited on time. Obviously, when people do estate planning, they want to transfer their monetary wealth, but there's the non-financial wealth that can be passed on too. The story of how grandma and grandpa came to this country from somewhere else, or maybe mom and dad came from somewhere else, and so they achieved the American dream. They worked hard, they made those incredible sacrifices for their family, and now they've got a successful business or what have you. And so the money is fine, and certainly that's what they've worked hard to be able to leave that to their families. But what about the stories about how they came to be here and the lessons that they learned about being in business and making a contribution back to the community that allowed them to be successful, etc. And I've seen, there used to be something I saw often on Facebook. There's services that they'll actually write your story, and that can be a wonderful keepsake about, how, they came to this country, and they were able to build a successful life and a successful business, etc. There are also companies that will do a videotape or that will put together kind of your family story. And it's very well done, very well edited, and beautifully produced. And it can be a real heirloom. I promise you, these are great things that we can, have conversations with clients about. So protecting the non-financial wealth is also a big consideration too. Okay, go on to the next one. And we're not soliciting anybody, obviously, but when we work, we help our clients figure out the best solutions for them so that the plan is right for them. We try to write in plain English. Sometimes legalese creeps in because, we're attorneys, but we try to write in plain English, and we also try to explain it in plain English too so that they understand it. I charge a fixed fee for my time. I don't like to charge hourly. That's just a practice preference for me. I just think hourly billing is basically can reward incompetence, and I don't like to do that. I like to, so that people know that when they hire us, this is what the fee is, and if they need anything, that they can call us or reach out to us. I want them to do that, and they don't have to be concerned that they're going to get charged a bill for a 2-minute phone call, but I had to round it up to 6 minutes because I had to bill at 1/10 of an hour. We don't do that. Go on to the next slide. All new clients, all prospective clients, when we work with them, they get a free 15-minute breakthrough call. It's either a phone call or a Zoom call. All I want to do is find out, are we a fit to work together, and how can I help them? And so then we kind of talk through how the process works. if they want to hire us, well, the next step in that process, if I think there's a fit and they think that we're a fit, we'll schedule a strategy session to basically, it's about an hour long, and we design a plan that's built for them and their unique situation. And then if they want to hire us, then, we'll get, we'll have them sign a retainer agreement, get us paid, and then we'll draft the documents, and then they'll come into a signing ceremony. We'll sign all the documents. I'm a notary, so I'll notarize all the documents, and then I'll witness the will along with our front desk receptionist. And so that way they've got their plan implemented. And then, if there are real estate deeds that need to be filed, we will do that and file them with the county recorder, so that now that's in the chain of title, and everybody, can relax a little bit now because we've got the plan implemented, it's funded, and life goes on.
Well, and I think that's an important thing to discover if it's a good fit, because when it comes to this type of planning, you're talking about very intimate wishes and topics. So,
yeah. And so anything that they share with us stays with us. I mean, the attorney-client privilege attaches, and I'm not the holder of the privilege, the client is. So unless they give us permission to share it, we can't. Ethically, we can't do that. And I can be disbarred for that. And, I worked too hard to get that license. When we design the plan, we can either meet with the clients in person or we can do a Zoom call. I think that's a little bit better because they can see us, and I can understand if I say something and they're frowning on the Zoom call. I can say, well, maybe I didn't explain that clearly enough, so let me see if I can rephrase it. We just want to make sure that we're communicating, that we're understanding what you're telling us, and that we're speaking into your listening, and that ultimately we have a plan that's designed the right way for you and your particular concerns. Okay, and let's see anything else. Well, I hope you feel lighter, knowing that you and your family are totally protected. Feels really good. And so I hope that this has been a valuable investment of your time this afternoon. Sarah, I thank you for the opportunity to share some wisdom with your listeners. And I hope that perhaps this will spur them to take action. I know people have the best intentions to get something done, but then life gets in the way, and I totally understand that. But perhaps this can be that spur to reach out to a local attorney, get something started so that you can have this crossed off your list, but then have that updated and maintained going through the years together.
Absolutely. And Rod, how can people contact you? So anybody listening today, and I believe you're licensed in California. I can't recall if you're licensed in
Tennessee, where I'm from originally, but I have colleagues all over the country who can definitely help. So if I'm not the best fit, I can help find somebody in that jurisdiction where your listeners are located that can, and I understand, you'd probably rather work with an attorney in your local area. I totally understand that. Best way to reach out to us is call us. My phone number is 858-465-8001, 858-465-8001. Or if you want to send an email, I'd be happy to hear from you. The email address is Rod, R-O-D, at Hatley, H-A-T-L-E-Y, lawgroup.com. Rod at HatleyLawGroup.com. And I see you put it in the chat.
So I've never actually typed in a comment before. So I will be reposting your contact information when I reshare the recording of this. So anybody listening, if you're wanting to learn more from Rod or explore his support for yourself or for an aging loved one, I do highly recommend that you reach out to him. He's been doing this for a long time, very well respected, at least here in San Diego. So use him as a resource for yourself, or to get connected with an attorney that's in your part of the country, so that way you can stay ahead of this. You don't want to be the train wreck. Remember, do the proper legal planning.
Yeah, well said. It's been a pleasure to spend time with you and your listeners today. Thank you so much for the opportunity, and I hope this was helpful.
Absolutely. Thank you so much for being our guest today, Rod, on the Empowering Aging podcast. And everybody, I will be seeing you again soon with another guest. If you are interested in being a guest on the podcast, reach out to me so we can go ahead and get you scheduled. You can email me at Sarah, S-A-R-A-H, at connectourElders.com. Thank you, everyone, and enjoy the rest of your week. Thank you, Rod.
You're welcome. Thank you.